This former teacher is admitted to having sex with an 11-year-old student. Allie Bardfield originally pleaded not guilty to the shocking charges last year, but now she is admitting she did it. And that's not all. I'll show you how this woman, who is in her 30s, blamed the 11-year-old for this case. I spoke with the victim's family's attorney about what could come next and whether they believe there could be more victims.
What they really want to take place, though, is that other kids and other families who may have been a victim of this woman's acts to feel confident that if they come forward, that we can, hold the school district accountable.
We're on the case presented by Law&Crime. I'm Chris Stewart. It's sad how often we talk about stories of teachers and other people in positions of power who violate that trust. But this story out of Illinois is one that stands out compared to many others. Here is video per WAND TV of Allie Bardfield in court in Macon County, Illinois. This is about 3 hours south of Chicago. This video is of a hearing where Bardfield admitted to sexually abusing one of her students who was just 11 years old at the time. This is Bardfield's mugshot from April of last year when she was arrested. Bardfield worked in the Decatur, Illinois public school system. She was considered a long-term substitute teacher for a 6th grade class. And like many of the teachers that we've talked about on this show who are accused of inappropriate behavior, on the surface, she appears to be the type of person who was deserving of that trust, who was playful with children, someone who parents could look to and feel good about leaving their children in their presence. According to police in Mount Zion, Illinois, though, on March 29th of last year, Bardfield had one of her 6th grade students over to her house for a play date. And that child's mom, after the play date, noticed her son acting differently. Again, this boy just 11 years old. According to police, the mom then checked her son's phone and social media, and then they talked about whether anything happened while he was at Bardfield's house. And that is when the boy said that his teacher had sex with him. We have more specifics on what police say happened that potentially played a role in how this case played out. But before I get into that, I want to show you this video of Bardfield making her first court appearance last year in Macon County, Illinois, per WAND. Here's the judge reading her the max punishment that she could face if she took this case to trial.
It's a Class X felony, punishable by 6 to 60 years in the Department of Corrections. That would be served at 85%, followed by a mandatory supervised release of 3 years up to natural life and up to a $25,000 fine. It is not a probation eligible offense. And if convicted, you would have to register as a sex offender for the rest of your natural life.
Bardfield had been held without bond since her arrest, and now by pleading guilty, we are learning more about what happened. Not only did Bardfield reportedly have sex with the boy, she also sent him $700 on Cash App and sent nude photos to him on Snapchat. WAND reports that Bardfield admitted to all of this during a police interview after she was read her Miranda rights. WCIA-TV reports that the boy spent the night at Bardfield's house and was with her for about 25 hours in total. Police say after the boy was brought to the police station to talk about what had happened with Bardfield, police came up with a plan for the boy to talk to his former teacher through text messaging, phone calls, and FaceTime, with officers and the boy's mom watching and listening. They say during those conversations, Bardfield talked about birth control and pregnancy. Bardfield also told the boy to delete the text messages, and then they moved to a phone call. Again, police are watching this as it's playing out. And during that call, Bardfield told the boy she couldn't get pregnant. This conversation, I will remind you once again, is between a woman in her 30s and a boy who was just 11 years old. Bardfield then said she missed the boy a lot. On April 3rd, police took Bardfield into custody. And what made this story even more shocking in some ways is what she said during a police interview. Because in that police interview, she put the blame on the 11-year-old, saying that the boy was the one who made advances on her. I put Allie Bardfield's name into truthfinder.com, and it showed me that she's lived in Illinois her entire life, and other than these charges that came about last year, she really didn't have a criminal record. She had a couple speeding tickets, but that's it. At Law&Crime, we partner at Truth Finder. We use it to get details on the people who are involved in our stories. But even if you don't work in true crime, it can be a great tool to give you some peace of mind. It's one of the largest public record search services in the United States, and with the paid subscription service, you get access to unlimited reports about almost anyone. And right now, you can get 50% off your first month of confidential background reports. Just go to truthfinder.com/OTC. Decatur Public Schools fired Barfield after her arrest, but a lawyer for the victim's family filed this lawsuit claiming what happened to the victim in this story was not an isolated incident, accusing the district of a lack of supervision that led to the abuse and not requiring employees to complete state-required training on physical abuse, sexual assault, misconduct, and grooming. I spoke to lawyer Asim Cunningham of the law firm Cunningham Lopez out of Chicago, who filed this lawsuit earlier today. Asim, what is the family's reaction to the plea deal in this case?
It has been a long ride for the family. After the way things, started out, it was very explosive and shocking, and to see it, almost come to an end was very relieving for the family because it's just been a lot of emotions every time you go back to court to see what's going on. A lot of hurry up and wait, which is hard for them.
Yeah, no, I bet. What are their thoughts on the deal? I know that the teacher will potentially get around 40 years. The sentencing still has to take place, but what punishment are they looking for in this case?
It's hard to say when you're talking about punishment because for the family of the victim, punishment doesn't return the innocence of the victim. It only punishes the person who did wrong. What they are really what they really want to take place though is that other kids and other families who may have been a victim of this woman's acts to feel confident that if they come forward that we can hold the school district accountable for the lack of supervision that resulted in Miss Barfield being able to commit these acts.
What kind of action are you anticipating that you'll take against the school district?
So currently pending in the Central District of Illinois is an action against the school district for a failure to adequately supervise their staff and failure to follow certain laws that require sexual harassment training by all staff, including substitute teachers.
Because in her case, I understand she was a long-term substitute teacher. To your understanding, is there a difference between the type of background checks that a tenured teacher, someone who had been there for a long time, and then a substitute teacher have to go through in the school district?
And according to the law, the background checks required are no different. There are, of course, different credentials that are required to become a tenured long-term teacher versus a substitute. But in terms of what is required to get into education, that's not substantially different depending on if you're a substitute or if you're full-time employed. However, what does change is the opportunity for the district to have eyes on those employees and have contact so that there's some level of contact and supervision that's ongoing. And so that's what we would like to explore more with this lawsuit.
What's the family expecting heading into a potential victim impact statement when it comes to the time for sentencing, and who would potentially speak during a hearing?
So the parents intend on speaking at the victim to make a victim impact statement for sure, and perhaps some other extended family. What makes it difficult is that in order to protect the anonymity of the John Doe in the case, um, there may not be a live statement by those family members just in order to protect the child's privacy. However, as I'd stated previously, it is very important to the family to make sure that other kids in the community and other families of children in the community understand that they no longer have to sit around and just take whatever treatment their kids are given. That if they take action, that there will be repercussions for faculty who act as Ms. Barfield did.
And I can't imagine what the victim went through in this case, and then having to see it all play out in a public forum, though their name and their identity is being protected. But just how are they doing?
From what I've been told and what I've observed, the child is thriving to some extent as best as possible. He's moving forward and doing what he can to do so. And the parents are trying as much as possible as well. Obviously, with this case, still looming, it has definitely taken up a lot of mental energy from the parents having to observe the case and keep tabs on what's going on. But by and large, and all things considered, they are doing pretty well at trying to move forward.
And is there anything I missed or anything you'd want people to know now that this case has moved forward, going into this area where she's taken a plea deal?
What I think on behalf of the family, what's really, really important for them to understand and for the community to understand, through our investigation, there have been other instances of malfeasance by teachers and faculty against the students, and many of the parents feel as though they've been treated secondhand in a lot of respects. The family of the victim really wants it to be known that you two can stand up and that there are actions that can be taken so that these sorts of things don't remain in the dark and they come to the light. And the more that they come to the light, that reform will take place in the Decatur community.
And does the family believe that there are more victims of Allie Bardsfield?
Um, I can't speak for the family directly. There has been information that has come to light, some of which has been put into the complaint against the school district that leads us to believe that there may be more victims of Miss Bardfield, and there are likely more victims of abuse and harassment by faculty in the Decatur public school system against students.
Sim Cunningham, the attorney for the victim in this case, thank you for taking the time to be with us.
Absolutely.
Bardfield pleaded guilty to having sex with the boy, and she will now be sentenced in September. Now, you might remember, at that first appearance, the judge said the max sentence could be as much as 60 years in prison. As part of this plea deal, the state is now asking for the max to be 40 years in prison. Joining us now is Patrick Provenzale, an Illinois trial attorney. Thank you for taking the time to be with us on Law and Crime. These cases are just never easy to talk about, and in this case, the victim is so young, 11 years old. What is your reaction to everything that Allie Bardfield actually admitted to now that she's taken this plea deal?
Well, first, Chris, thanks for having me on. I'm happy to come on and talk about this case. And like you said, awful situation, circumstance for this young person's family and for him or her. I know we don't know much about the victim. I think, I think anyone who hears a story like this, first, it's terrible that a trusted adult, would take advantage of someone so young and tender like that, and then just the idea that this happens way too often in schools or in communities. That this kind of thing seems to crop up more often than anyone would like to hear.
Yeah, all too often. And in this case, she takes a plea deal. Originally, in her first court appearance, I know the judge had said that she could face a maximum of 60 years behind bars. Under this deal, the maximum, and she still has yet to be sentenced. Prosecutors are expecting to ask about 40 years. What do you make of prosecutors going in the direction of having a plea agreement in this case?
So, first of all, these kinds of offenses, when you're talking about a victim who's so young, under the age of 13, and such a terrible situation of sexual activity, the legislature in Illinois has appropriately made the penalties very stiff. So this is a Class X felony in Illinois. That's a non-probationable felony, meaning that you have to go to prison if you're found guilty or plead guilty to it. And it actually has an extended term built into the period of incarceration. Normally, a Class X in Illinois would be 6 to 30 years, non-probationable. This is 6 to 60, and appropriately so, with victims who are so vulnerable and conduct that is such as described here, that's so terrible. So prosecutors, when they look at cases like this, have to obviously take it seriously for the protection of the community and for justice for the victim. And so they are going to be aggressive on how they pursue both the prosecution to prove guilt and then as well to seek appropriate punishment for like I said, the protection of the community and justice for the victim. 40 years is a high number. I think what that is the cap that the prosecutor has communicated to the judge that they could or otherwise would allow the judge to enter as a sentence here. I think the agreement that has been entered is a limited one. It's a plea agreement simply for a plea of guilty to the more severe offense of the predatory criminal sexual assault of a child, the non-probationable class X, in exchange for the prosecutor dismissing the grooming charge, which is a class 4. But what this person will be sentenced to ultimately will be the result of what's in this situation in Illinois we call a blind plea, meaning the defendant has pled guilty in the blind, not knowing without any agreement with the prosecutor what the sentence will be, and asking the judge to exert or impose some leniency, and the state, on the other hand, asking for a severe penalty of up to 40 years. So very appropriate conduct by the prosecutor in this case, given the circumstances of what has been admitted, what the investigation revealed she had done, both by way of taking advantage of such a young person, paying that person money. Those are all really aggravating circumstances that are appropriate to pursue aggressively.
And it seemed like, had this moved forward through a trial, that prosecutors would have had a strong case. There was one report that she admitted to having sexual activity with this young child after she was read her Miranda rights. Why move forward with a plea deal? What are the benefits of a plea deal when, for those of us on the outside, you would say you have her, like you're going to get a conviction and going to be able to hold her to the furthest extent of the law. What are some of the benefits as to why a prosecutor might go in the direction of a plea deal, and even a blind plea in this case?
To protect the victim and the victim's family, and as long as in the pursuit of that type of a plea arrangement, the prosecutor is reserving the ability and the flexibility to pursue a very severe sentence, which certainly that they're doing here. But anytime you can save the victim the trauma and the terror of having to hit a witness stand, and imagine an 11-year-old having to testify about these circumstances because the 11-year-old would have to, it would be really re-traumatizing to this young victim to have to go through that type of experience when, if the defendant is willing to plead guilty, which obviously they are here, and like you said, certainly because there was such a strong evidence of guilt, that that you take that win, for lack of a better word, from the prosecutor's perspective, to save the victim the trouble, the terror, and the trauma of having to go through that type of really awful experience.
I mean, to your point, I mean, to have an 11-year-old talk about it in open court would just be so difficult. So now, as she awaits what her sentence is going to be, what goes through the judge's mind in making the decision of how long she'll be in prison for?
So the process in Illinois starts with the probation department in the county, in this case, Sangamon County, conducting a background investigation of the defendant. And so they will speak with her. They'll talk with the victims. The victims have an opportunity to prepare, the young person as well as the family members, to prepare a victim impact statement to present to the judge. And so it's sort of a broad and detailed picture is given to the judge of the defendant's background, for anything that might be offered by the defendant's lawyer in mitigation to reduce the punishment, as well as to develop the picture of what might be aggravating in terms of the impact on the victim, the vulnerability of the victim, the trust that this part-time teacher had violated both within the community and for this young person and their family. And so the judge will have all of that information in a pre-sentence report, as well as what the prosecuting attorney will present to the judge at a sentencing hearing. And in Illinois, it's effectively a straightforward but two-part process. Prosecutor puts on their case of what's aggravating, and there are statutory factors that the prosecutor will point to as to what is aggravating and why the court should consider a severe sentence. And then on the other hand, the defense will then have an opportunity to present evidence in mitigation and statutory factors that are met that may be mitigating, to ask the court to take those things into consideration in offering some leniency or mercy in the sentence. And so the judge really has a very well developed and detailed picture of all of these things when the judge makes a decision about what justice calls for as an appropriate length of incarceration.
She's in her 30s now, so let's just say she gets 40 years in prison. She'd be in her 70s, so she'd be, nearing the, certainly in her elder years by the time she gets out. How likely would it be that she would be a sex offender for the rest of her life if she ever gets out of prison?
Well, a conviction for predatory criminal sexual assault of a child requires lifetime registration. There isn't any relief from that. Lower level sex crimes have lesser periods, but this is a lifetime registration requirement. So once she is released, and under Illinois law, this type of offense would serve at 85% of the period that the judge enters for incarceration. So whenever she does get out, she will undergo a period of pretty intense supervision by effectively a parole officer. They call it mandatory supervised release in Illinois. And then she's going to then continue to have to register with any local police department wherever she lives.
On the civil side of this, the family of the victim, they have an attorney, and when this arrest was made, they said that they would be pursuing legal action against the school district in Decatur, Illinois. What type of legal trouble? I mean, the school did fire her when she was a long-term sub. She's fired when she was arrested. I'm not sure of the background checks, but often schools do background checks ahead of time. I don't believe she had any sort of criminal record ahead of time. But what type of liability could the school be in for this happening? And this was a student in one of her classes.
So the liability stems from a couple of things. The first is usually in Illinois, schools, their employees, the officials, the school board, they're all mandatory reporters, meaning that if they're ever aware of any suspicion of circumstances that would indicate any kind of abuse, physical, sexual, they have to report it to the Department of Children and Family Services or to a local police. And so the failure to meet that obligation, just in general, as educators who are charged with the care of the children in their custody, and community members who, we should all be looking out for children and their well-being, their failure to recognize or see the red flags that are in front of them could expose the school district and the employees or specific employees to liability. There would be liability under both state and federal law, depending on what the circumstances were. So, for example, if colleagues of this defendant were aware that she was setting up these play dates with this young person, or she was giving this young person money on cash apps, and these colleagues failed to disclose that information or report it to any official, that would be very strong evidence that the school district or those employees violated both state and federal law in terms of their duty under state law to report these types of circumstances that would clearly suggest some risk to the young person, or under federal law from a constitutional perspective of failing to recognize that all of us as citizens have rights to due process, so that if the government is aware of something that puts us at risk, they have to give notice of those circumstances so that individuals are not deprived of their right to bodily integrity as a result of deliberate indifference of government actors. And so it would be effectively a 14th Amendment due process claim under federal law. Those kinds of exposures, they are very hard to prove because it's a very elevated degree of fault that you have to establish for liability under both state and federal law, because whether it is under either scenario, the employees, the school districts enjoy a certain degree of protection under the law from liability. State law immunities, federal law qualified immunity, and those kinds of things, they're high hurdles to clear. So it really has to be a compelling case that the employees or officials running the school district had it right in front of them that something was going on, that they really should have acted on it, and that they were indifferent to that and allowed it to happen.
Because, I mean, again, I know we were talking about just you see so many of these cases, and I think by and large, the majority of teachers are not crossing the line like Allie Bartfield did in this case, and unfortunately the stories that we so often see. When putting together a lawsuit against a school district, because we often see that as well from victims, where you have the criminal side of it, then there's the civil side of it. What goes into determining the compensation number that you would be looking for in putting together a lawsuit? Because I think of, the Decatur, Illinois school district. This isn't a private school that would have, I'm sure, millions of dollars, but what goes into into kind of thinking about what you would actually go for in a lawsuit and what you want to see come out of it?
So in my experience and in studies that have sort of pointed this out too, there are two primary drivers to what juries think about when they award compensation to victims. And the first and most direct driver is the amount of harm that was caused. And so it will be really granular analysis of the psychological and emotional impact to this young person and their life, and the vulnerabilities that were exposed by this adult who was trusted, because the harm caused by an adult violating a child's trust is lifelong, and and these kinds of things live with the victims forever. They find it very hard to shake the vulnerability and the attack on their psyche. Who can you trust after a teacher violates you like that? That's a very lifelong thing that victims of these kinds of acts struggle with. So the harm to the young person is going to be the primary driver, but secondarily, oftentimes juries will take into account the aggravating circumstances under which the harm was allowed to occur. Because if you're suing the school district, obviously you're not suing the school district because they're the ones who sexually assaulted or violated this individual. It's because they allowed it to happen. So how egregious their indifference was, how egregious their conduct was in allowing it to happen, what were the facts that were the red flags that they should have seen and acted on, or that they did see and failed to act on, that would really sort of drive outrage in a jury who hears the story of what happened to this young person. So when looking at a case like this, judges, juries, lawyers, everyone focuses on those two primary things, because those are really the things that society needs to address. It's compensate the victim and to address the misconduct of individuals who are egregiously dropping the ball on what they should be doing. And so I think those are things that will be looked at in the case like this.
Yeah, and though the plea deal moving forward, we'll see what the sentence is, and then the civil part of it, what that will look like. Patrick Provençale, thank you for taking the time to be with us, Illinois trial attorney. It's great to have you on Law and Crime. We appreciate it.
My pleasure, Chris. Thank you.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.